Professor Namyong Lee's essay, Long, Legal Standards Must Be Clearly Established so that the World Heritage nomination of the capital fortifications of Hanyang does not undermine Seoul's development and permitting system. The capital fortifications of Hanyang, comprising the Hanyang city wall, Bukhansan fortress, and Tangchundaeseong, are core historical and cultural assets of the Republic of Korea, encapsulating the defensive system and urban structure of Joseon-era Hanyang, the former capital. National efforts to nominate these assets for inscription on the UNESCO World Heritage List deserve full respect. However, a World Heritage Initiative is not a symbolic declaration. It is a commitment of state governance. Such a commitment must be clearly defined through law and institutions. I believe the essence of the current issue lies not in a conflict between preservation and development, but in the fact that regulatory constraints are already operating in the absence of clear and legally defined standards. When standards are unclear, citizens cannot plan, and when planning becomes impossible, both property rights and the city's time come to a halt. This essay is written in accordance with the structure and underlying concerns of the civil petition to be submitted to the National Assembly. Rather than relying on emotion or slogans, it diagnoses the problem from an institutional and structural perspective and clearly identifies what the National Assembly and the government must do. Through this essay, I hope that honest citizens will gain an accurate understanding of the current situation and make a rational judgment about how preservation and everyday life can coexist. At present, the capital fortifications of Hanyang remain at a stage prior to final inscription as a UNESCO World Heritage Site. Nevertheless, buffer zones, height restrictions, and landscape management standards established during the nomination and conservation planning process have already been incorporated into domestic laws, ordinances, and urban management plans, functioning preemptively as criteria in development and permitting decisions. As a result, citizens experience regulations that effectively presume final inscription, even though the site has not yet been listed. The fundamental problem is that it is not clearly explained why, to what extent, and on what legal basis these regulations are being applied. The UNESCO World Heritage Operational Guidelines are recommendations shared by the international community. They are not laws. Any restriction on property rights or development rights within Korea must be grounded in clear constitutional and statutory authority. The current confusion does not stem from flaws in the World Heritage system itself, but from administrative action occurring before the boundary between international standards and domestic rule of law has been properly defined. It is precisely at this point that the legislative role of the National Assembly is required. In current administrative practice, the UNESCO World Heritage Operational Guidelines are often interpreted and applied as if they were equivalent to domestic law. Consequently, development restrictions not explicitly prescribed by statute are being imposed through administrative guidance or internal standards. From the perspective of rule of law governance, this is a serious concern. The moment non-statutory criteria restrict citizens' property rights, both the legitimacy and predictability of administration are undermined. Under global standards, international norms provide direction, while domestic law supplies the framework for implementation. For international standards to operate domestically, they must be translated through legislation enacted by the National Assembly. When this translation process is omitted, administration defaults to the most conservative interpretation, and regulation is felt as excessive. The success of a World Heritage Initiative depends not on the severity of regulation, but on its legitimacy and transparency. The UNESCO World Heritage System presupposes a phased management structure. The objectives and intensity of management necessarily differ between the nomination stage and the post-inscription stage. Yet within the current institutional environment surrounding the capital fortifications of Hanyang, this distinction has not been clearly articulated in law. As a result, administrative authorities tend to apply regulations in advance as if post-inscription conditions already applied. This is not a matter of administrative intent, but of institutional design. When stages are not legally distinguished, administration inevitably selects the safest option, the strongest possible regulation. This choice suppresses urban dynamism and leads to prolonged restrictions on the exercise of property rights. Calling for legal differentiation of regulatory scope by stage is not a demand for deregulation, but a demand for precision in regulation. The development and permitting system related to cultural heritage operates through a multi-layered structure involving central government agencies, the Seoul metropolitan government, and district-level governments. The structure itself is not the problem. The problem is that this layered system is not perceived by citizens as operating under a single coherent standard. When the perception spreads that identical sites and similar development activities may be subject to different standards or conditions, trust in public administration rapidly deteriorates. Central government sets preservation principles and permissible criteria. The Seoul metropolitan government administers urban plans and landscape standards, and district governments execute permits. Unless this division of roles is clearly aligned through law and standardized criteria, interpretive discretion expands and consistency of outcomes weakens. Public interest is fulfilled not through strictness, but through consistency. Inconsistent regulation damages the public interest and amplifies conflict. When development and permitting standards are not clearly articulated, citizens cannot reasonably formulate land use plans. As the ability to predict development feasibility diminishes, investment and renewal are delayed, and such delays accumulate into long-term constraints on the exercise of property rights. This problem extends beyond individual inconvenience and is ultimately transferred as a cost to the city as a whole. Housing supply is postponed, improvements to aging buildings are deferred, and local economic vitality weakens. If restrictions on property rights arise for public purposes, they must be accompanied by clear standards and reasonable compensatory mechanisms. Otherwise, the public interest is misunderstood as a justification for shifting costs onto specific individuals. Providing predictability is not a discretionary choice of administration. It is a fundamental obligation. The National Assembly must clearly legislate development and permitting standards in connection with the World Heritage nomination of the capital fortifications of Hanyang. It must distinguish the regulatory scope applicable at the nomination stage from that applicable after final inscription and systematically align the criteria for buffer zones, height restrictions, and landscape regulation within the legal framework. The principles governing domestic application of the UNESCO operational guidelines must be clarified so that administrative guidance does not supplant statutory law. In addition, mechanisms must be established to ensure that central government, the Seoul metropolitan government, and district governments apply uniform legal standards. For long-term development restrictions, rights relief mechanisms, including compensation, mitigation, and alternative measures, must be codified. This is the legislative responsibility required to protect both cultural heritage and the fundamental rights of the people. Legislation is only the starting point. Completion lies in administrative implementation. Standards established by law must be easily accessible and immediately verifiable by citizens. From the perspective of e-government and a digital platform government, civil service systems must be comprehensively redesigned. By entering a property address, citizens should be able to view applicable regulations, development feasibility, required procedures, and expected timelines at once. This constitutes one-stop civil service. Beyond that, interagency consultation and data linkage should be automated internally so that citizens are not required to move between institutions. This is non-stop civil service. The legal basis of regulation, decision-making criteria, procedural status, appeals, and relief mechanisms must all be provided through a single digital platform. Only then can individual planning and property rights be substantively protected. Such institutional reforms make it possible to balance cultural heritage preservation with urban development. legal stability for the property and development rights of Seoul's citizens is secured, while confusion and disputes among administrative bodies are reduced. The World Heritage System ceases to be a source of conflict and instead functions as a platform that enhances urban competitiveness. The international community values countries with trustworthy management systems more highly than those with merely stringent regulations. Cultural heritage protection is an important responsibility of the state. However, that responsibility must always be exercised within the framework of the rule of law. The World Heritage Initiative for the capital fortifications of Hanyang must not bring Seoul to a standstill. If the National Assembly establishes clear standards and the government implements them digitally, preservation and citizens' lives can coexist. This is the clear message I wish to convey to both the people and the National Assembly through this essay. Thank you for watching Professor Namyong Lee's essay, Long.